Hello, hello, hello. Good evening, everyone. Hi, everyone. Good evening. My name is Ifeoma Odunlami, immigration attorney from the Odunlami law firm here in New Jersey. I'm here because I want to discuss the newest law in town, President Biden's parole in place. So come on in, say hello as you come in. It's not going to be a really long live, but I just wanted to talk about this because it's a new law, and I want to go over really quickly a general overview of what you should know about the Biden's parole in place. All right, so thank you guys for joining me. Hello, Obioma, how are you? Hello, TikTok, how are you? Hello, YouTube, Facebook. Thank you guys for joining in. So, I want to talk about the Biden's parole in place, and I'm going to explain what it is, what the requirements are, and basically just go over do an overview of some important things. This came out, I think it was on Monday, was it Friday maybe? But it went into effect on Monday. We have the Federal Register, which basically spells out how it's going to be, the process. 94 pages of it. I skimmed it really quick so I could get the general idea and I could bring it to you guys. Hello, Jokan, how are you? So let me explain what Biden's parole in place is, and then I will go into who qualifies and who doesn't qualify. So if you come to the United States without inspection, without parole, you're not admitted. Typically, people who come through the border, right? Even when you come into the United States and you get married to a US citizen or you have a child who's a US citizen, you're not going to be able to adjust your status because of the manner of your entry. The entry was illegal, so therefore you must file a waiver seeking forgiveness for your manner of entry. And once the waiver is approved, you have to leave the country, go back to your country through go to the embassy, get interviewed, be approved for a green card, and come back. Now, the problem with this is that it takes a long time, a very long time. And sometimes some people go out and, something comes up, they're not able to come back in for a very long time, basically continuing to fracture the family unit. So President Biden implemented this new parole in place, which they call the implementation of keeping families together. That is the basis of this parole. So what this parole does is it cures the unlawful entry. So the person who qualifies does not need to leave the United States. They don't need to file a waiver. They don't have to leave the United States. They don't have to go to their country, to the embassy, go for an interview, and come back in. So the parole in place basically cures the legal entry so that they can adjust their status in the United States if they have no inadmissibility issues. And then they can, get their green card all without leaving the United States. So for those of you who came inspected, which means you had a visa, you came, the visa is expired, this law does not apply to you. It does not apply to you because people call my office and they want to know whether it applies to them. I want to let you guys know, if you're a non-citizen who you don't have lawful status, but you came with a visa or you were paroled in or you were inspected, this does not apply to you, okay? Does not apply. And it only applies to spouses, stepchildren of US citizens, widowers married to US citizens, their criteria. I'm going to go through it right now, okay? So let's start. Having understood what the parole in place is meant to do, let's go into the criteria for the spouses. And I'm going to go into the criteria for stepchildren and criteria for widowers. So the criteria for spouses is, number one, that you are present in the United States without admission, without parole, like I discussed, right? You didn't have a visa. You came in through the border. Then number two requirement is you have to show that you've been physically present in the United States for 10 years as of June 17, 2024. 10 years, okay? The third thing is you have to show that you have a legally valid marriage to a U.S. citizen as of June 17th, 2024. You were married to a U.S. citizen either on or before June 17, 2024, and you do not have a disqualifying criminal history, and you do not pose a threat to national security or public safety. That's a requirement for spouses. Now, the requirement for stepchildren, right, is that they're present in the United States as well. Their manner of entry was not legal, so they're present without admission, without parole. They've been physically present in the United States as of June 17, 2024 through the date of filing. Now, this is a key thing, right? So you guys listen to this. They have a parent who has a legally valid marriage to a U.S. citizen as of June 17, 2024. And the stepchild must meet the definition of a stepchild based on immigration law. So to qualify as a stepchild, the parent and the American citizen must have gotten married before the child turned 18. And then that marriage must have taken place as of June 17, 2024, right? On or before. And of course, there's no disqualifying criminal history, and it does not pose a threat. The stepchild does not pose a threat to national security or public safety. And so that's the eligibility criteria for stepchildren. So let's talk about the eligibility criteria for widowers. Is the same as the spouse, the 5 things we mentioned. But in addition, the widower of a U.S. citizen must have had an I-130 filed on their behalf at the time of the U.S. citizen's death, or they file an I-360 within 2 years of the U.S. citizen's death. They must be unmarried when the immigrant visa petition is adjudicated. And the good thing is the widower's children may be eligible for visa approval as the derivative of their widower parent. So that's, in a nutshell, the people that qualify, right? A lot of our clients who came in with a visa, B1, B2, you don't qualify, period. As long as you don't check off number 1, that's it, you don't qualify. Now, let's talk about people who are in removal proceedings. So if you're removal proceedings, or, this is an important, this is important, and you need to talk to a lawyer. This is not something you can do on your own. You want to talk to a lawyer and get properly advised, properly directed, okay? So if you are currently in removal proceedings, currently before a judge in removal proceedings, and you do not have an order of removal, you are eligible to request parole in place. All right? Now, if you have a removal order, but you've not departed the United States, and the order is an executed removal order, you are subject to what they call a rebuttable presumption of ineligibility. What that means is you're presumed not to be eligible for parole in place. However, it's rebuttable, which means you can push back on it. You can, give reasons why you're eligible. So basically, in the exercise of his discretion, because parole in place is discretionary, USCIS will decide, if on a case-by-case basis, whether that person should be granted parole in place. So the USCIS will evaluate the facts and circumstances underlying the unexecuted final removal order, including the basis of the removal, why was that person in the removal, whether and all of that. There are many things. There's a whole list of things that they're going to look at to make that determination. So that's why it's a rebuttable presumption. But if you have an executed order of removal, you've been ordered removed and you've been deported, you're not eligible for parole in place. You're not eligible, period. So let's talk about things that can get, let's assume that you're granted parole in place. These are the things that can get your parole in place revoked, right? Hope you guys are taking. Well, somebody says this parole is not helpful. Maybe not to you because maybe you didn't come because you came in with a visa. But what I think it's what I don't remember the amount. Is it 400,000 or something amount of people who actually would benefit from this? I don't remember the amount, but there's a lot of people that would benefit from this. You know, people coming in through Canada, coming in through Mexico. You know, so if you get parole in place, don't assume that that allows you to leave the United States. No. You need advanced parole to leave the United States because parole in place does not grant you re-entry into the United States, okay? Now, if you make false representation or conceal material facts in the application, that can get your parole terminated. If DHS determines that your presence is not warranted in the United States, that can get your parole terminated. Now, the parole is good for 3 years. So how will they let you know that your parole is going to be terminated or has been terminated or whatever is when they issue you a notice to appear in immigration court. And that constitutes written notice of parole termination. So let's talk about the other thing that which is the criteria that requires that you don't have a qualifying criminal history. It's important that you don't have a qualifying criminal history. So let's talk about that. If you have a pending criminal history right now, you're in court, but the case has not been decided, right? You cannot apply for parole in place until the case has been decided, and hopefully it's not a crime that would qualify for, that would put you in make you ineligible, right? So if you have a pending case, don't bother applying until it's concluded, right? You want to make sure those charges are resolved, and then you can apply. If you have a felony conviction, you're not eligible. Felony conviction includes murder, rape, there's a whole list of them in the Federal Register of what qualifies as a felony. You do not qualify, including felony DUI, driving under the influence. If you have that, you do not qualify for parole in place. So if you have other criminal convictions apart from minor traffic incidents, minor traffic offenses don't qualify, you're fine, right? If it's minor traffic offenses, but if it's any other thing apart from minor traffic offenses, it will result in a rebuttable presumption of ineligibility, which means that you're presumed not to be eligible, but you're welcome to give reasons that DHS can consider to see whether they can give you that grant of parole. So let's see. Now let's talk about filing the form. You use the form I-131F. That's the form that you use, and you can only file it online. And if you have a lawyer, your lawyer can use their own account to file for you, which is really great. The filing fee is $580, and you must pay the $580 because you cannot waive the filing fees. Now, you can waive the filing fees when you're filing for a work permit, but you cannot waive the filing fees for the I-131F. So let's talk about the things you need to put together to submit so that you can get your I-131F petition properly done. So they want a photo identity, which could be your passport, your birth certificate, your driver's license, something that has your face and identifies you as the person that you say you are, right? Then that's number one. Number two, they need evidence of your relative's status as a U.S. citizen. So they want to see that your spouse is a U.S. citizen, your step-parent is a U.S. citizen, or your deceased U.S. Spouse is a U.S. citizen. So to show that, you want to have something such as their passport, certificate of naturalization, their U.S. Birth certificate showing they were born here, their consular report of birth abroad, and all that kind of stuff. Naturalization certificate that will establish that your U.S. citizen relative is a U.S. citizen. And number 3, you want to show it's a qualifying relative, so qualifying relationship. So if you're filing as a spouse of a U.S. citizen, you want to have the marriage license that shows that you are indeed married and you got married on or before June 17, 2024. You want to show, if you have been divorced, that those prior marriages were properly terminated. And you want to show the birth certificate for the stepchild. You want to show the birth certificate of the stepchild to show that that child was under the age of 18 when they married, when their parent married the U.S. citizen. And you also want to show a death certificate if you're filing as a widower, right? So now this is the one that takes, this is one requirement that a lot of people ask questions about, which is the evidence of continuous physical presence in the United States. So if you look at this, right, if you go online and look for this, it's called the Filing Guide for Form I-131F, right? This is what it looks like, right? So if you go to the USCIS website you can go to where you find the I-131F, click on it, and you'll find the filing guide, right? This is really important because it basically breaks down everything, well, most of the things you need, right, for submission. Now, the legal element of it, like who qualifies and making, presenting a case that shows that that person warrants the discretion of being granted parole in place, you want to talk to a lawyer because they can help you. So, continuous presence basically is USCIS wants proof for a spouse that they've been here in the United States, or they've been here in the United States continuously for 10 years. So you want to show proof of things that will lead them to think that, yeah, you were here present. Now, they don't want you to submit document for every day, for every week, or for every month. They're looking at the totality of the basically, they're looking at the totality of the circumstances for that would lead them to believe that you've been here continuously in the United States for 10 years as of June 17, 2024. So an example of that would be things such as rent receipts, right? Even if your name is not listed, as long as you submit evidence that connects you to that address, right? Now, if you have school reports showing the names of the school and your attendance record, that would be helpful. You have hospital or medical records. You have official records from maybe a religious entity such as a baptism, a first communion, or wedding, showing that, where it was done and you were present at that place. That would be helpful. If you have children that were born, definitely that's helpful because you have a birth certificate for your children here in the United States, shows that you're present. So you want to kind of put this like for 10 years, you want to get a bunch of things for the first year, a bunch of things for the second year, a bunch of things for the third year, just to show continuity for the 10 years. All right. And then if you have an attestation by a religious leader or union or any organization regarding your physical presence, that would be helpful. And any document that you think is helpful, like if somebody sued you, or maybe you're involved in a car accident on, some streets in Newark, that's helpful because now you have something that shows that you were there, you were present, So anything that you can think of, that these are just examples that will help you establish your continuous presence. That's what you want to put together and submit. Now, let's talk about evidence of disposition of any criminal record. USCIS wants to get disposition of your criminal records. Now, in this book, they basically tell you what they're looking for. So if you've been charged with any crime, you want to provide the disposition of it. Sometimes they actually ask for, let me look for the page. They actually ask for for the police records, the police report, all of that stuff. So let's see, let's see. I thought I had highlighted it, but maybe I didn't. But I would say that if you have any criminal record, you definitely want to talk to an attorney. This is not something you want to file on your own. And now there's even juveniles. Sometimes juvenile records are sealed, right? USCIS is saying, if you can get it, you should. But if you can't, then you want to explain, I guess you can, because there's some states that will not unseal it. So, and if there's some records you cannot get for some reason, because in New Jersey, some of the marijuana records, right, they're not even in existence anymore. So you want to get a letter saying that, this is not available. And remember, with marijuana, anything more than 30 grams of marijuana is a problem. So that would still, be a problem for you. So I think that's, I can't really find, let's see. Okay, here it is. I did highlight it. So basically it says, if the charges against you were handled in juvenile court and the records are from a state with laws prohibiting their disclosure, this evidence is not required, right? If you've ever been arrested for any felony or misdemeanor in the United States or crime in any country other than the United States and no charges were filed, you must submit an original official statement by the arresting agency or applicable order confirming that no charges were filed for each arrest. If you're unable to provide such documentation or it's not available, you must provide an explanation, including a description of your efforts to obtain such evidence. If you have ever been charged with or convicted of a felony or misdemeanor in the United States or crime in any country other than the United States, submit an original or court-certified copy of the complete arrest record and disposition for each incident. For instance, dismissal order, conviction and sentencing record, acquittal order. If you're unable to provide such documentation or it's not available, you must provide an explanation, including a description of your efforts to obtain such evidence. If you've had any arrest or conviction vacated, set aside, sealed, expunged, or otherwise removed from your record, submit an original or court-certified copy of, an original or court-certified copy of the court order vacating, setting aside, sealing, expunging, or otherwise removing the arrest or conviction, or an original statement from the court that no record exists of your arrest or conviction. If you're unable to provide such documentation or it's not available, you must provide an explanation, including a description of your efforts to obtain such evidence. Now it tells you you do not need to submit documentation concerning minor traffic violations such as driving without a license, right? Unless they were alcohol or drug related. All right. So those are the things that you need to know about parole in place. And another thing you need to know, so once you get a parole in place, you file your work permit and you get it, that in itself does not establish you for the green card. That just says now you can adjust your status in the United States. You're still going to have to file whatever you need to file to obtain your green card, the I-130, the adjustment of status, So I think that's pretty much it. So I'm going to take a couple of questions and then I'm going to head out. And Alaji says, my prima facie expired since March, still not received the new one. Is that normal? It's not abnormal. It's not a big deal really, because the prima facie, they're supposed to give it to you automatically every 6 months after the initial one for the first year. And sometimes they forget, so typically you should ask your lawyer to send a letter to them. But the prima facie really is something that would basically tells you that your case, they've looked at the case. It looks like, you've made a good initial submission, and but it's not an approval. But a lot of people need the prima facie because it gives them benefits, and those benefits depend on what state you are in. So Alaji, don't worry about that. But if you really want to get a copy of it, reach out to the lawyer and ask them to send a letter asking you, the VAWA unit, to send you the prima facie, and sometimes takes them a little while, but they should do that. So Glove Master says, please chat about the procedure for submitting I-693. As I'm aware, medical gets submitted at the end of your case process, but my attorney is submitting now based on my VAWA with the I-485 packet. So Glove Master, right now, because there's no expiration for the medical form, there used to be in the past, because there's no expiration, now we can submit it with the VAWA and the I-485 package. In the past, when there was it would expire within 2 years, it made no sense to submit it because by the time the VAWA is, a decision is made on the VAWA, it would have expired. So your attorney is doing the right thing, okay? And Tracer says, this patrol is not helpful. It encourages people to come illegally. Actually, I don't agree with that because, people are going to come here, whether there's parole in place or whether there's no parole in place. People have many reasons for coming to the United States. So the Biden administration, they did a lot of studying into this and decided that it was important for the idea of keeping towards the idea of keeping families together. I mean, there's also military parole in place. That parole is something that has always been in existence, and there's a lot of research into making. In fact, I think there's. I read something about one of the reasons why parole in place. I think, let me see if I can find this reasons. Some of the reasons that this has been implemented, but trust me, it's not encouraging anybody to come because nobody knows that it's going to be there. And the people who qualify for it, you have to have been here as of June 17, 2024. And that's it. So people are not coming here thinking it's possible to get parole in place. Trust me on that, because it's not something that is expected. The last parole in place, military parole in place, has been there for a while. So yeah, it doesn't really. It does. I don't agree with you. So somebody says they've been married over 15 years, didn't get a divorce after the husband walked out. Will I qualify? So you won't qualify because it requires you to be married to first of all, the parole in place is just excuses the manner of your entry, but you have to be in a marital union to be able to get the green card. Remember, your petitioner has to file the form I-130. You have to be able to adjust your status based on the U.S. citizen petitioners filing for you, or a 360 if the person is a widow or widower. All right, James Tay, nice to see you. How are you? Vipul Patel, good news. I think it is. We're always grateful and happy when there's some immigration good news that allows even a small percentage of people to get some status. It helps the economy. It puts families together. Because we all know that immigrants make America great. Okay, so if it doesn't happen for you now, maybe it might happen later. Does permanent bar qualify? No, because the guidelines say that you must be otherwise eligible to adjust status. So if you have a permanent bar, you won't qualify for parole in place. So Hama says, while my case is pending, can I move to another state to work without changing my address? Well, Hama, you're required to, if you move to another place, right, and you're required to change your address with USCIS within, I think it's 10 days of the move. Now, if it's a temporary move because wherever you live before is your permanent address, but you're just maybe going for a month or two, then technically you can say that's just a temporary stint working. But if you're moving, right, you must. That's the law, okay? And it's really important to do this because if immigration is sending you documents and you've moved and you don't get the letter or the decision or whatever it is, it's not an excuse that you moved. Unless you filed a change of address, then it would be their fault because they didn't use the new change of address that you gave them, okay? So Diane White says, if you're married to a citizen and have a port of entry, can you apply for PIP? If you're married to a citizen and you were inspected or paroled in, nope, you cannot apply. All right. So Mr. Lionel says you need to ask questions for your friend. Can you inbox me? I don't answer questions inbox. So the best thing to do is call my office, 973-993-1900. And Dad says, thank you for your help. You're welcome. So let's see if I can get a couple of questions right here from Instagram. So Ariana says, can my husband file for 601 waiver due to his felony, due to my medical issue? So Ariana, I'm gonna need more information, and it's gonna depend on what his crime was. It has to be a waivable crime. So call the office, 973-993-1900. Would love to help you. All right. So Odogu says, if the USCIS improves someone's work permit and advance parole this month of August, can somebody travel with it next month, September? If you have your advance parole, you can travel. However, I always tell people traveling outside the country with an advance parole is not a guarantee that you will be able to come in, because if you have any inadmissibility, either out, when you left, and USCIS is aware of it, they may stop you from coming back in. But if you have no issues, then it doesn't matter that they gave it to you just now. As soon as you get it, you can use it. Okay. All right. So I think that's pretty much it. Let's see. I'm going to talk to a couple of people on TikTok. So somebody says, I filed I-130 for my stepson and spouse. I'm a U.S. citizen. Can I apply parole in place? My son is 3. So you're a U.S. citizen. It depends on how your stepson came into the United States. Remember, your stepson must have come in without inspection, without parole. So the requirements for that, and I mentioned them at the beginning. So you can go back to the beginning of the video and look at the 5 requirements for filing parole in place. So McKee says, after how long of a marriage can I apply for VAWA? The regulations don't give you any length of time to apply for VAWA after you get married, So if you are in an abusive relationship, talk to a lawyer and get your application moving. Okay. All right, guys. Thank you for joining me. I know it's a little late, so I'm going to be heading out of here, but I wanted to come in and talk about parole in place because people are already getting approvals. Yes, people are getting approvals. They file today, the next day there's an approval. So don't tarry on this. And another reason you don't want to tarry on this is because remember what happened with DACA? People apply for DACA, and then, those people who don't want young people to have a life in America filed lawsuits, and DACA was basically stopped. So you don't want this to happen to you. So if you qualify for parole in place, get your application rolling. They're literally taking 1 day to approve parole in place. So do that, and take advantage of this if this will work for you. And if you need our assistance, we're always happy to assist. 973-993-1900. If you have any criminal records or any issues, you definitely want to talk to an attorney to make sure that it's worth your while to apply. The filing fee is, I believe it's $580. All right. Take care, everyone. See you next time.